Thank you, everyone, for standing by. We will now resume our conference call today with Derek Witherspoon, Branch Chief for FLSA. Sir, you may proceed.
Good afternoon, everyone. My name is Derek Witherspoon, and I'm the Branch Chief for the FLSA Child Labor Team. I would like to thank everyone for joining us for this webinar, which will focus on the Child Labor Enhanced Penalty Program, commonly known as CLEPP. If you have any questions during this webinar, please type them into the chat box right away. At the end of our presentation today, we will answer as many questions as possible, although we anticipate that we might not have enough time to answer all of your questions. We have developed many guidance documents that will also help answer your questions, and we have provided links to those materials at the end of our presentation. Before we continue with this presentation, I would like to emphasize that this is an internal presentation intended to provide guidance and information only to our wage hour staff. This presentation should not be shared with the general public. Now to our training objectives. Number 1, to explain the CLEPP guidance recently issued in our Field Assistance Bulletin dated December 19, 2016. Number 2, to explain changes to the C&P amounts per the Federal Civil Penalties Inflation Adjustment Act, Improvements Act of 2015, commonly known as IAA. Finally, to review the factors used when determining the amounts of the C&Ps and assessing the penalties. Now we will move to the child labor coverage section and its related background information. Child labor coverage under Section 212C is dependent upon a minor either being employed individually in commerce or in the production of goods for commerce, or in an enterprise engaged in commerce or in the production of goods for commerce. If a minor is illegally employed under these circumstances, a violation of Section 212C exists. The violation exists regardless of where such minor may be employed or the type of employer's business. It also exists regardless of whether there is a removal of goods or a shipment or delivery meant for commerce. Here are some of the requirements for non-ag employment. For 14 and 15-year-olds, if the occupation is not specifically permitted in the regulations, it is prohibited. Under Section 203L of the FLSA, Congress provided the Secretary of Labor the authority to prescribe by regulation or order as necessary for the enforcement of 2 child labor provisions. One, as indicated on the slide, is the authority to issue regulations governing the employment of 14 and 15-year-old persons in non-hazardous occupations other than mining or manufacturing. Prohibited occupations for minors 14 and 15 years of age are listed in 29 CFR 570.33. Prohibited occupations include manufacturing, mining, or processing occupations, including occupations requiring the performance of any duties in workrooms or workplaces where goods are manufactured, mined, or otherwise processed with limited exceptions. Other prohibited work, for example, includes occupation that involve power-driven machinery, operation of motor vehicles, outside window washing, and all baking and cooking activities. Work in freezers and meat coolers is also prohibited. It also includes any occupation that the Secretary of Labor has found and declared hazardous for the employment of minors between 16 and 18 years of age, or detrimental to their health or well-being. However, permitted occupations for 14 and 15-year-olds are found at 29 CFR 570.34. Most of the occupations are in retail, food service, and gasoline service establishments and involve employment opportunities in office and clerical work, sales work, kitchen work, cashiering, and waiting and busing tables. Such permitted tasks must also be confined to the time of day and the period of time the Secretary declares to be appropriate. This topic will be further discussed on the next slide. The slogan for 14 and 15-year-olds is, "If it's not specifically permitted, it is prohibited." The only type of work minors ages 14 and 15 can perform is listed in the regulations. Child Labor Regulations 3 describes the hours of work and conditions of employment for 14 and 15-year-olds. This employment is confined to certain periods and conditions that do not interfere with their schooling or adversely affect their health and well-being. As seen on this slide, 14 and 15-year-old minors can only work in permissible occupations outside school hours, no more than 3 hours on school days, and never more than 40 hours a week. They also cannot work before 7 a.m. or after 7 p.m., except from June 1st through Labor Day, when the evening hour is extended to 9 p.m. Under Section 203L, the Secretary of Labor has the authority to establish what occupations are hazardous for youth who are 16 and 17 years of age. Unlike 14 and 15-year-olds, 16 and 17-year-olds may perform any task at any time unless the Secretary of Labor has declared the task to be particularly hazardous or detrimental to their health and well-being. There are 17 child labor non-agricultural hazardous occupations orders, which are contained in Subpart E of 29 CFR Part 570.51 through 570.68. The most frequent violations are found in HO occupation orders such as HO2 motor vehicle occupations, HO7 power-driven apparatus, HO10 slaughtering, meat processing, or rendering occupations, HO11 power-driven bakery machine operations, and HO12 power-driven paper product machines, scrap paper balers, and paper box compactors. There are no federal hours limitations placed on the employment of youth once they reach 16 years of age. This may differ from a state's requirement. The slogan for 16 and 17-year-olds is, "If it's not specifically prohibited, it's permitted." The only type of work minors ages 16 and 17 cannot perform is listed in the regulations. This slide summarizes the non-agriculture child labor requirements. Remember that 14 and 15-year-olds can only work in specified occupations outside school hours, with limitations on the periods of time each day and week. For 14 and 15-year-olds, if it's not specifically permitted, it's prohibited. 16 and 17-year-olds have no limitations on the number of hours they can work and can perform any job except for those that fall under the hazardous occupations orders. For these minors, remember that if it's not specifically prohibited, it's permitted. The parental exemption applies where such employee is employed solely by his parent or by a person standing in the place of his parent, and who is not employed in any non-ag HO. For more information, see FOH 33E00. Next, here's a summary of the child labor standards which regulate the employment of children in agriculture. These standards are less restrictive than those for non-agricultural workers. In general, the child labor provisions for work in agriculture are intended to prohibit the employment of minors under the age of 16 when school is in session, prohibit the employment of minors under 16 in designated hazardous orders, and to provide a degree of parental supervision or consent where minors under 14 are employed in agriculture. Minors under 16 may not, unless exempt or not covered, be employed in any of the designated categories of hazardous agriculture occupations. A complete list with explanations can be found at 29 CFR 570.70, Subpart C, FOH 33F03, and Sections 13C2 of the FLSA. Some of the prohibitive occupations involve operating or assisting with a corn picker, cotton picker, feed grinder, and power post hole digger, or loading timber, working from a ladder or scaffold. It is also prohibited to operate or assist with power-driven machinery, such as forklifts and circular or band chainsaws. Minors under the age of 16 are not allowed to work on a farm, in a yard, or pen, or occupied by a bull or stud horse for breeding purposes. The parental exemption applies where such employee is employed by his parent or by a person standing in the place of his parent on a farm owned or operated by that parent or person. For more information, see FOH 33F03. Now, Ernie Weiss, Senior Advisor of the FLSA Child Labor Branch, will now walk you through the background of CMPs. Ernie?
Thank you, Derek. These child labor civil money penalty guidelines, originally issued in January 2010, were applied to the very first CLEPP child labor cases. This presentation has been revised to clarify certain sections and to provide additional information to the field offices that was not included in the original guidance. Like Field Assistance Bulletin 2016-5, this presentation includes discussions on general rules for child labor CMP assessments, including background, CLEPP causation, and non-CLEPP serious injury, child labor record keeping, and hot goods provisions. The Fair Labor Standards Act was amended in 1974 to provide, for the first time, the imposition of civil money penalties for violations of the Act's child labor provisions. Prior to this, the Wage and Hour Division enforced the child labor provisions primarily through actions for injunctive relief and criminal sanctions. This segment of the presentation discusses the guidelines the Wage and Hour Division follows to determine when an assessment of child labor civil money penalties under the Fair Labor Standards Act, FLSA, 29 U.S.C. 201, is appropriate, as well as the amounts of the penalties Wage and Hour Division will assess. These guidelines draw heavily on the child labor civil money penalty process the Wage and Hour Division has developed over the past 40 years. Some of the guidelines reflect the May 21, 2008 amendments to Section 16E of the FLSA made by the Genetic Information Non-Discrimination Act of 2008, or GINA. See 29 U.S.C. 216E 1AII. GINA increased the maximum child labor CMP from $11,000 to $50,000 for any child labor violation that causes the death or serious injury of any employee under the age of 18, and provides that such penalties may be doubled for repeated or willful violations. These maximum penalty amounts have been and annually will be adjusted, but we'll discuss this further later in the presentation. These guidelines also incorporate into the Wage Hour Division's assessment process interpretations provided to the Wage and Hour Division by the Secretary of Labor's Administrative Review Board and comport with Regulations 29 CFR Parts 579 and 580. It is the policy of the Wage Hour Division to promote a vigorous and active child labor enforcement program including the assessment of civil money penalties, or CMPs, in appropriate amounts which are consistent with FLSA Section 216E, and to issue assessments that will serve as an effective deterrent to violations of FLSA child labor provisions. Child labor CMPs are an important tool the Wage and Hour Division uses to attain and maintain compliance with the nation's child labor provisions. The Wage and Hour Division assessing official, DD or ADD, shall review every child labor CMP case to ensure the investigation findings are accurate and that each child labor violation is adequately documented and entered into WIZARD. Wage and Hour investigators, and particularly DDs and ADDs, must have a firm understanding of the CMP Form WH-266 and all other factors that are considered in the assessment of CMPs. They must be able to explain the assessment, particularly how it takes into account the Part 579 factors, in testimony to an administrative law judge who can review the assessed CMP and adjust it as he or she deems appropriate. For example, it is not enough to say, "I just filled out the form," or "I hit the button in WIZARD." This slide is not exhaustive, but contains some of the unchanged child labor rules. When determining the amount of a child labor CMP for minors who have not suffered a serious injury or death, the Wage and Hour Division adheres to unchanged procedures that were followed before the 2008 CLEPP amendments to Section 16E. The Wage and Hour Division will continue to use a table that assigns a predetermined initial assessment amount to each type of violation for which a child labor CMP may be assessed. A list of the violations can be found at 579.3. A multiplier of 2 may be applied when child labor violations are found to be willful or repeated. A similar multiplier would be applied if the employer falsifies or conceals the child labor violation or fails to give credible assurances of future compliance. Along with the webinar invite, you received an attachment with charts consisting of the old and current agriculture and non-agricultural CMPs. Beginning now and at various points throughout the rest of the presentation, we will be discussing the old and current CMP amounts, and it may be easier to follow along if you have the charts handy. The Wage and Hour Division will generally assess a child labor CMP of $6,000, currently $6,697, for each violation involving the illegal employment of a 12 or 13-year-old, and a child labor CMP of $8,000, currently $8,930, for each violation involving the illegal employment of a child under the age of 12. These enhanced penalties, which involve both agriculture and non-agricultural employment, were established only for those violations that occurred on or after June 1, 2010. These assessments involve the illegal employment of workers under the age of 14 and would be in addition to any other assessments made for child labor violations involving that same youth. In addition, such assessments may be increased based on the established aggregating factors, but the total civil money penalties involving the employment of the minor may not exceed $11,000, currently $12,278, unless the violations caused or contributed to the serious injury or death of the minor, which could raise the amount of the penalty to $50,000, currently $58,808, or as much as $100,000, currently $111,616. Additional information regarding the increases will be discussed later. In addition, all child labor injuries, CLEPP or non-CLEPP, must be reported to the national office through official channels. The required information about reporting is contained in FOH 73D00. I will now turn over the presentation to Serena, who will talk about CLEPP and CLEPP serious injury.
Thanks, Ernie. As previously mentioned, on May 21, 2008, President Bush signed the Genetic Information Non-Discrimination Act of 2008, affectionately known as GINA. The Wage Hour Division created the Child Labor Enhanced Penalty Program, otherwise referred to as CLEPP, to incorporate the Genetic Information Non-Discrimination Act of 2008 amendments to Section 16E of the FLSA into its existing child labor CMP assessment process. GINA increased the maximum child labor CMP from $11,000 to $50,000 for any child labor violation that causes the death or serious injury of any employee under the age of 18 and provides that such penalties may be doubled up to $100,000 if it is a repeated or willful violation. However, the $50,000 and the $100,000 levels will increase annually per the IAA and are currently $58,808 and $111,616 respectively. The statute also provides a causation standard which requires that a particular relationship exists between the violation and the serious injury or death of the minor employee. The causation standards of CLEPP, child labor CMP amounts, differ from non-CLEPP violations, and the penalty amounts for CLEPP violations are significantly higher than those of non-CLEPP violations. As to the note on the slide, the Federal Civil Penalties Inflation Adjustment Act, Improvement Act of 2015, also known as the Inflation Adjustment Act, or IAA, increased the maximum penalty amounts from $11,000 in 2008 to $12,080, from $50,000 to $54,910, and from $100,000 to $109,820 on August 1, 2016. The adjusted child labor civil money penalty levels apply to all penalties assessed after the effective date of August 1, 2016 for associated violations that occurred after November 2 of 2015. On January 13, 2017, the first of the annual increases occurred, increasing the $11,000 level from the $12,080 in August of 2016 to $12,278. It also increased the $50,000 level from the $54,910 in August of 2016 to $58,808, and the $100,000 level from the $109,820 in August of 2016 to $111,616. There are two categories of child labor injuries. The first we'll discuss is the CLEPP serious injury, which is a serious injury that was caused by a child labor violation and involves permanent loss or substantial impairment to one of the senses, sight, hearing, taste, smell, a permanent loss or substantial impairment of the function of a bodily member, organ, or mental faculty, including the loss of all or part of an arm, leg, foot, hand, or other body part, or a permanent paralysis or substantial impairment that causes loss of movement or mobility of an arm, leg, foot, hand, or other body part. Section 16E of the FLSA states that CLEPP assessments up to $50,000 may be made for each child labor violation that causes the death or serious injury of any employee under the age of 18 years. This statutory language requires a particular relationship between the violation and the serious injury or death of the minor employee. Specifically, the CLEPP causation standard will be met if 1, the death or CLEPP serious injury would not have occurred if the child labor violation had not occurred, and 2, the death or CLEPP serious injury was a foreseeable result of the child labor violation. We'll discuss the two criteria on the following slides in more detail. As previously mentioned, the statute provides a causation standard which requires that a particular relationship exists between the violation and the serious injury or death of the minor employee. The but-for causation standard is generally easy to establish if the injury occurred while the child was working in the violative act. You will need to show that the injury or death would not have occurred if the child had not been employed in violation of child labor laws. For example, as indicated on the slide, if the child was not using the circular saw, the child's arm would not have been injured by the circular saw. The slide also has an example of where the but-for causation would not be applicable. A minor was operating a skid steer in violation of HO7. While walking across the floor of the facility, the minor fell into an auger and his leg was amputated. But-for causation would be hard to establish here because there is an argument that the minor's use of the skid steer was not the but-for causation of the amputation. Please note, even if you have a CLEPP series injury, if the child labor violation did not cause that injury, you will end up assessing under non-CLEPP, which will be discussed later. Sometimes the analysis can become involved when multiple factors have to be taken into consideration. However, each factor will be reviewed and taken into consideration toward the outcome. For example, as seen on the slide, if a minor was operating a baler in violation of HO12 prior to slipping on the floor of the facility where he fell into another piece of equipment that amputated his finger, the but-for causation standard would be difficult to establish here because there's an argument that the minor's violative work in HO12 was not the cause of the amputation. In another example, a minor was employed to use a forklift in violation of HO7 to transport vehicles to place on a car lift, and then use a circular saw in violation of HO14 to dismantle the car. The car lift was defective and snapped, causing the death of the minor. Yes, the use of the forklift was a violation, but there could be an argument that the use of it did not cause the death of the minor. Yes, the use of the circular saw was a child labor violation, but there could be an argument here as well that the use of it did not cause the death of the minor. The use of the defective car lift was not a child labor violation and appears to be what caused the death of a minor. If the child labor injury or death would have occurred even if the child was not employed in violation of a child labor law, the but-for causation standard will not be established. In the example just discussed, if the minor had not used the forklift or the circular saw and still used the car lift, it could have rendered the same result. CLEPP causation also requires foreseeability. Foreseeability is the harder standard to meet, as foreseeability requires us to show that the serious injury or death was a foreseeable or predictable result of that particular child labor violation. A serious injury or death that results from the dangers that are inherent to a particular piece of equipment will meet this standard. For example, if a minor slips and falls to his death while performing roofing repair work on a snow-covered roof in violation of HO16, the minor's death would have been foreseeable. Therefore, the foreseeability standard under CLEPP causation would have been met. Conversely, if a minor who has been employed in the performance of roofing work was severely injured in an automobile accident while leaving the job site, the injury would not have been foreseeable. Despite the fact that he was employed in violation of HO16, the injury sustained could not have been predicted and would therefore not meet the foreseeability standard of CLEPP causation. In summation, CLEPP CMPs can only be assessed if the death or serious injury meets 1. The definition of a CLEPP serious injury, which is an injury that was caused by a child labor violation and involves the permanent loss or substantial impairment of one of the senses, a function of a bodily member, organ, or mental faculty, or that causes the movement or mobility of a body part. And 2, the causation standard, which consists of 2 prongs, A, but for, and B, foreseeability. And now I'm going to turn it over to Jennifer Kinley, who is the Regional Enforcement Coordinator in the Western Region, to continue the discussion on non-CLEPP serious injury and non-CLEPP non-serious. Jennifer?
The second category of injury is non-CLEPP and has 2 parts: non-CLEPP serious injury and non-CLEPP non-serious injury. A non-CLEPP serious injury is an injury that does not meet the definition of CLEPP serious injury because it does not fall within one of the 3 categories of serious injury, which includes loss, paralysis, or impairment, or fails to meet the level of causation required by CLEPP, and which does not meet the definition of a non-serious injury because it requires the care of a medical practitioner beyond the initial treatment or curtails the youth's normal activities for at least 5 days. Serious injuries include situations where a minor is required to return to a medical practitioner after an accident to have stitches removed or for an evaluation of the healing process. The non-CLEPP causation standard will be a much easier standard to meet. You will need to establish whether the violation contributed to was a factor in the death or serious injury. The violation does not have to be the only factor or the primary factor that caused the death or serious injury, and it does not have to be a foreseeable outcome of the violation. As discussed on a previous slide, in the context of meeting the definition of causation for CLEPP, if a minor using a power-driven nail gun on the ground level of a building is injured by an object that was dropped by another employee from the 2nd floor of that building, the foreseeability part of causation would not be met because there wasn't a way to predict that an employee would drop an object. However, under non-CLEPP, the causation standard only requires that the prohibited work was a factor in the serious injury. And in this case, if the minor had not been doing the prohibited work, he may not have been in the place where he was injured. The same analysis is applied to the skid steer example. The second part of non-CLEPP is a non-serious category. A non-serious injury is any injury that requires treatment no more extensive than first aid and results in the youth missing school or work or having their normal activities curtailed for less than 5 days. We will discuss non-CLEPP, non-serious a little later in the presentation. Wage and hour investigators should ask whether the State Workers' Compensation Office has issued an impairment rating regarding the injury. If not, the national office can obtain an impairment rating from a medical professional for a permanent loss or paralysis, whether CLEPP or non-CLEPP, with a request through official channels through your regional office. These ratings assist with determining the level of impairment, thus assisting with the assessment of the appropriate CMP level. The AMA guide to the evaluation of permanent impairment is used by medical professionals, including at workers' compensation offices, to generate consistent impairment ratings for particular types of injuries. Charts in Field Assistance Bulletin number 2016-5, pages 13 and 14, tell you the proper baseline CMP amount to assess for particular impairment ratings prior to and after August 1st, 2016. It's harder to obtain impairment ratings for injuries that are not a permanent impairment. As a general matter, the medical professionals don't like to do impairment ratings unless the patient had reached the maximum medical improvement. If we can't get an impairment rating, we will consider other factors, including the length of the recovery period and time lost from school and work instead. You have an injury case. How do you know to assess under CLEPP or non-CLEPP? First, you must determine if the death or injury meets the definition of CLEPP, which is a permanent loss or a substantial impairment of one of the senses or the function of a bodily member, and or permanent paralysis or substantial impairment that causes the loss of the movement or mobility of another body part? If yes, you then have to determine if it meets the causation standard, which for CLEPP serious injury is two parts. First, the but-for part, meaning the violation would not have occurred if the child labor violation did not occur. And second, the foreseeability part, meaning the death or injury was a foreseeable, predictable outcome of the child labor violation. If yes to all three, you will assess under CLEPP. If no, non-CLEPP will apply. Please note, even if it is a death or serious injury, you still may not be able to issue the CLEPP assessment if the injury was not caused by the child labor violation, but we will discuss that later in the presentation. Wage and hour investigators will need to gather as much information about the nature of the injury as possible from the young employee and his or her family, including documentation from medical professionals and workers' compensation offices. Some of the questions that will need to be answered are, what was the nature of the injury? Was there an amputation? Was there a permanent injury? If not, how long was the youth hospitalized? Was follow-up treatment required? And how long was the recovery period, for example? Wage and hour investigators will need to conduct a detailed interview with the minor, but be mindful that the interview statement alone may not reflect the true nature of the injury. Here are two examples of CLEPP assessments for injuries. Meeting the definition of permanent loss is a 16-year-old who was operating a meat tenderizer machine in violation of HO10 and got his finger stuck in the machine. His index finger was amputated to the first joint, and the impairment rating was 6%, which was an initial CMP assessment of $15,000. The $15,000 on the slide was assessed for a violation that occurred prior to November 2nd, 2015. The $15,000 was the lowest amount on the CLEPP serious injury chart. Currently, the impairment rating would be classified as Tier 3 on that chart, and the appropriate initial CMP amount is 30% of the maximum CLEPP CMP, which is currently $58,808 or $111,616 if willful. Applying the current calculation based on 30% of $58,808 equals a maximum CMP assessment of $17,642. If it was a willful or repeated violation, applying the current calculation based upon 30% of $111,616 equals a maximum CMP assessment of $33,485. Please refer to Field Assistance Bulletin 2016-5, page 13. Meeting the definition of substantial impairment, a minor fell from a scissor lift while assisting with roofing work in violation of HO7 hoisting apparatus and HO16 roofing operations, and sustained major injuries requiring surgery and extensive rehabilitation. The impairment rating was 4%, which is less than the 5% rating required for CLEPP serious injury. But the long recovery period of 9 months warranted a CLEPP assessment at the Tier 2 level. Prior to IAA, the Tier 2 level was $25,000 on the CLEPP chart. Per the IAA, this maximum amount can be up to 50% of the maximum CMP, currently $58,808. Applying the current calculation based on 50% of $58,808 equals a maximum CMP of $29,404. If the definition does not meet CLEPP serious injury, then non-CLEPP will apply. As previously stated, the non-CLEPP causation standard is much easier to meet as it looks to see whether the violation contributed to or was a factor in the serious injury or death of the minor. The violation doesn't have to be the only or primary factor that caused the death or serious injury, and it doesn't have to meet the foreseeability standard either. As seen in the example on the slide, it's not foreseeable that a child using a power-driven nail gun on the ground level of a building would be injured by an object dropped from the second floor of the building. But the use of the nail gun was a factor that contributed to his injury because he wouldn't have been standing in that place if he wasn't using it. An example of a situation where a non-CLEPP CMP assessment would not be appropriate is a youth operates a circular saw at work. He leaves work at his regularly scheduled time, and is injured on his way home when a drunk driver hits his car. The use operation of the circular saw was not a factor that contributed to the injury he sustained in the car accident. This slide contains examples for non-CLEPP serious assessments for injuries. Please take a moment to read the examples. Also, note that per the IAA, all CMP amounts have been and annually will be adjusted for inflation every January.
Excuse me, this is the operator. We have lost the audio.
Okay, Santina?
As previously mentioned, the second part of the non-CLEPP category of injuries is non-CLEPP non-serious, which is any injury that requires treatment no more extensive than first aid, and that results in the youth missing school or work, or having their normal daily activities curtailed for less than 5 days. The Wage and Hour Division will generally determine an initial assessment amount based on the table of predetermined amounts. If the violation contributed to a non-serious injury, the Wage and Hour Division will apply a multiplier of 3 to the base amount of the civil money penalty. If the employer and the violation comport with the criteria established for reductions for small businesses, the resulting CMP may be reduced. We'll discuss the small business reduction criteria later in this presentation. Field Assistance Bulletin number 2016-5 highlights areas where the Wage and Hour Division might not assess a CLEPP or non-CLEPP CMPs, even if the injury technically qualifies because circumstances may support a reduction in the CMP. See also charts in Field Assistance Bulletin number 2016-5, pages 13 through 15. Next, Marquita will be discussing the CMP assessments and factors. Thank you.
Thank you, Jennifer. The Department fully accepts the findings of Congress regarding the important role the assessment of civil money penalties plays in deterring violations and furthering the policy goals of its regulations. For additional information regarding these regulations, see Public Law 101-410, which is the Federal Civil Penalties Inflation Adjustment Act of 1990 and Inflation Adjustment Act of 2016, commonly known as the IAA. This is especially true regarding the child labor rules, where preventing violations literally saves lives and preserves the futures of our most important asset, our children. By raising the maximum penalty amounts, as previously discussed, Congress has consistently indicated that CMPs should be meaningful. Also previously mentioned per the IAA, which was effective August the 1st of 2016, the maximum child labor CMP levels have been and annually will be adjusted for inflation every January. The current CMP levels associated with violations after November 2nd of 2015 can be found on our website, which will be provided at the end of this presentation. Wage Hour believes that the assessment of a CMP for violations of the child labor provisions generally is necessary to achieve the objectives of the FLSA. Some CMP assessments are a strategy designed to impact compliance in a specific industry or geographic area. However, Wage Hour will consider the facts of each case when making a determination of whether or not to assess the CMP. Next, we'll discuss some of the factors Wage Hour will and will not take into consideration. The initial child labor CMP amounts in Wizard, which are generated from the tables posted on the Internet, take into account many, but not all, of the regulatory considerations. The initial assessment amounts are set relatively low in comparison to the maximum amounts that may be assessed because they make several assumptions concerning the gravity of the violations. For instance, The initial CMP amounts generated by Wizard assume that the employer does not have a history of violations, that current violations are not willful, and that only one child is illegally employed. This means that wage hour will not generally reduce an initial assessment amount because these conditions apply. The FLSA requires that the assessing official take into consideration the size of the business of the person charged with a child labor violation when determining whether to assess a child labor CMP and the amount of the child labor CMP that will be assessed. The size of the business and the gravity of the violation are the only two statutory required factors or considerations that must be taken into consideration, and the FLSA is neutral as to what actions wage hour takes when considering them. Furthermore, the FLSA does not direct wage hour to raise, lower, or modify a proposed child labor CMP initial assessment amount when taking these two factors into consideration. It just directs wage hour to take them into consideration when determining the amount of the assessment. 29 CFR Section 579.5 delineates wage and hours interpretations of Section 216E3 of the two statutory considerations made when determining the amount of the assessed child labor CMP. Regarding the size of the business factor, 29 CFR Section 579.5b directs the assessing official to take into account the number of employees employed by that person, and if the employment is in agriculture, the man days of hired farm labor used in pertinent calendar quarters, the annual dollar volume of sales or business done, the amount of capital investment and financial resources, and other information that may be available relative to the size of the business of such person. Please note that wage hour has programmed Wizard to take into account the first two regulatory factors addressing the size of the business. Wizard, though, is not programmed to take into account the third and fourth regulatory factors listed above, which are capital investment, financial resources, and other available information relative to the size of the business. The assessing official must consider, in particular, the employer's amount of capital investment and financial resources and any other information relative to the size of the business, as well as any mitigating factors that may be present. Wage hour has programmed Wizard to reduce the initial CMP amount when an employer qualifies as a small business employer. This is known as the small business reduction. The number of employees an employer has is one of the tests used to determine if the small business reduction is applicable. Wage hour considers the small business reduction when, among other things, the employer employs fewer than 100 employees. The wage hour child labor CMP assessment process also uses an employer's annual dollar volume and not profits, because an employer's profitability can be artificially but legally consumed by such things as excessive depreciation, owner-manager salaries, and investments in equipment and technology. Wage hour has programmed Wizard to only apply the small business reduction when the employer's ADV is not greater than $1 million. The failure to make a profit, regardless of the reason, does not excuse any child labor violations and is not an appropriate factor to consider when reducing an initial child labor CMP amount. Wage hour has not programmed Wizard to take into account the amount of capital investments and financial resources or other available information relative to the size of the business. Consequently, the assessing official must take these factors into consideration before making an assessment. The assessing official may become aware of an employer's claims of a financial inability to pay a child labor CMP, or that it would experience a severe financial hardship if required to pay a large and sometimes any child labor CMP assessment. These claims are often made prior to the assessment of a child labor CMP, but after the employer has been advised of a child labor violation, and more frequently during the appeals process. Prior to taking such claims into consideration, the assessing official should rely on the same documentation provided by the employer to substantiate an inability to pay child labor CMPs, and review all the facts and documentation prior to considering a post-assessment adjustment. For example, the assessing official may consider, in relation to all other required considerations, an employer's claims that the assessment will cause a severe financial hardship. The assessing official must consider any other information relative to the size of the business when considering making a small business reduction. Next, Benicia, Regional Enforcement Coordinator from the Southwest Region, will discuss the gravity of the violations and hot goods. Benicia?
Thank you, Marquita. This slide lists the factors to be considered for the gravity of violation standard provided in the regulations under 29 CFR 579.5C. We will review each factor in detail in the following slides. The initial CMP amount generated by Wizards assumes that the employer does not have a history of violations and the current violations are not willful. The initial assessment amounts are based upon only one child being illegally employed. A separate CMP is imposed for each additional child who is employed illegally. The initial child labor CMP also takes into account the age of a child employed, the nature of the violation, and the result of the injury. For example, the initial CMP amount assigned to a Reg 3 violation takes into account the age of the child, the occupation in which the child was employed, and the time of day that the violation occurred. However, Wizard is programmed to take into account whether the violations are willful and are repeated, as well as the severity of any injury based on the WHD investigator's entry into the system. 29 CFR 579.5C also directs the assessment official to consider or take into account duration of the illegal employment of the minor. Therefore, the assessment official must independently consider the duration of the violative employment while determining the ultimate assessment. If the volatile employment lasted for only 1 day, and there are other extenuating circumstances that resulted in the youth being employed in violation of the Act only on that 1 day, the assessment official may consider reducing the penalty. Extending volatile employment, on the other hand, may be an indicator of willfulness. See 29 CFR 579.2. The initial child labor CMP table establishes a relatively low initial CMP amount based on the assumption, among other things, that the employer had no history of violation, evidence of willfulness or failure to take proper precautions, and the total number of minors employed illegally by the employer. If a history of prior violations exists, the WHD investigator inputs this information, and Wizard is programmed to double the initial CMP amount, both CLEPP and non-CLEPP violations. The small business reduction will normally not be applied when an otherwise qualified employer has a prior history of violations. The initial CMP amounts generated by Wizard are based on the assumption that the current violations are not willful. The initial CMP amounts are based upon only one child being illegally employed. A separate CMP is imposed for each additional child who is employed illegally. WHD division considers the age of the minor when determining the gravity of the violation. Generally, the younger the child employed in violation, the more grave the violation, and the higher the initial child labor CMP amount. WHD division considers a violation involving the illegal employment of a child who is too young to work to be extremely grave. This is the very type of oppressive child labor the Fair Labor Standards Act
was enacted to eliminate. Such violations are as grave as those which cause or contribute to the serious injury or death of a young worker. Accordingly, as previously mentioned in an earlier part of the presentation, Wage and Hour will generally assess a child labor CMP of $6,000, currently $6,697 for each violation involving the illegal employment of a 12 or 13-year-old, and a child labor CMP of $8,000, currently $8,930 for each violation involving the illegal employment of a child under the age of 12. The initial child labor CMP amount takes into account the age of the child employed and the nature of the violation. For example, Wage and Hour will assess a higher CMP for a violation of a non-agricultural hazardous occupation order when performed by a 14-year-old, which is currently $2,176, than when performed by a 17-year-old, which is currently $1,730. In addition to assessing a CMP for CLEPP violations resulting in a serious injury or death of a minor, the Wage and Hour Division has a child labor CMP assessment process that utilizes a multiplier of 3 for child labor violations that result in a non-serious injury. A non-serious injury is an injury that requires treatment no more extensive than first aid and requires the youth missing school or work or having their own normal activities curtailed for less than 5 days. The Wage and Hour Division also has a child labor CMP assessment process that can use a multiplier up to 5 for all other minors performing the same volatile act as the one that causes or contributes to the death or serious injury of another minor. This is referred to as bundling. An example of bundling would be a 15-year-old was injured while operating a chainsaw. This was a serious injury. 10 16-year-olds were found to have operated a chainsaw during the same investigation period. In this instance, a multiplier of up to 5 could be applied to the standard base CMP for the HO CMP computation for the 10 16-year-olds that worked in the same prohibited HO. One penalty per child is assessed for each type of child labor violation performed by the child, regardless of the duration or frequency of the violation. For example, only one penalty will be assessed for the illegal employment of a 15-year-old in violation of Child Labor Reg's 3-hour standard, whether the violation occurred only once or every day throughout the child's 9-month employment. The Wage and Hour Division's assessing official may consider the circumstances surrounding individual violations, non-HOs and not involving children under the legal age of employment, and the frequency of occurrences. In situations where the volatile employment lasted only 1 day, other than an HO or Reg 3 occupation, and whether there are other extenuating circumstances that resulted in the youth being employed in violation for that 1 day, the assessing official may consider reducing the child labor CMP. Extending volatile employment, on the other hand, may be an indicator of willfulness. In addition to the size of the business and the gravity of violations factors we just discussed, the regulations 29 CFR 579.5 D1 and D2 further provide for the assessing official to consider, where appropriate, 2 additional sets of mitigating circumstances. However, these factors are not programmed into Wizard. Therefore, they must be independently considered by the assessing official. The first set of factors, as listed on this slide, are found under CFR 579.5 D1 and consist of whether the violation is de minimis and whether the employer has given credible assurances of future compliance and whether a CMP is necessary to achieve the objectives of the Act. The Wage and Hour Division considers a child labor violation to be de minimis in very limited situations, such as a Child Labor Reg 3 violation that involves the employment of no more than one minor, the hour standard is violated by no more than 15 minutes, there are no more than 3 such violations during that minor's employment with that employer, and the hours violation are the only child labor violations found in the investigation. Generally, Wage and Hour has concluded that the assessment of a CMP is not necessary to achieve the objectives of the Act when the violations are truly de minimis and the employer has given credible assurances of future compliance. The next set of factors are found under 29 CFR 579.5D2 and concern whether the employer has no prior history of child labor violations and the violations involve no intentional or heedless exposure of any minor to any obvious hazard or detriment to their health or well-being and were inadvertent. Also, the official shall consider if the employer is in violation has provided credible assurances of future compliance. In addition, the assessment official must determine whether a CMP is necessary to achieve the objectives of the Act. If either set of factors in 29 CFR 579.5D1 or D2 is present, the assessment official must give each consideration based on the facts of the case and determine whether it is appropriate to adjust the initial assessed penalty. This slide contains a list of some of the most common employer's defenses for violative acts. Wage and Hour Division should not take these types of explanations into consideration when assessing a child labor CMP. Instead, the Wage and Hour investigator should gather all the information from the fact-finding stage of the investigation when making a determination of whether or not to recommend a CMP assessment to the assessing official. I would now turn it over to Ernie, who will discuss hot goods.
As we stated near the beginning of the presentation, Section 212C coverage is based upon either the minor's performance of covered activities or the minor's employment in a covered enterprise, which makes the Act applicable. However, Section 212A coverage is not reliant upon Wage and Hour demonstrating that a minor was engaged in the production of goods, but rather that a minor was illegally employed in or about the establishment where the goods were produced, and thus allows the prevention of those goods being shipped because of the illegal employment. Section 212A coverage is applicable when minors are illegally employed in or about an establishment which produces, manufactures, ships, or delivers goods. The employer's act of employing minors illegally in any establishment producing goods is what classifies those goods as hot goods. Section 212A prohibits a producer, manufacturer, or dealer from shipping or delivering hot goods in commerce. As stated previously, Section 212A only applies to hot goods and prohibits a producer, manufacturer, or dealer from shipping or delivering those hot goods in commerce. Again, to establish hot goods for purposes of Section 212A, the Wage and Hour Division does not have to show that a minor was engaged in the production of goods. Wage and Hour must only demonstrate that a minor was illegally employed in or about the establishment where the goods were produced within 30 days prior to the removal of the goods from the establishment. If 30 days pass after the child labor violation and no further violations have occurred, the hot goods will have cooled and shipment from the establishment is permitted. If the goods are removed before 30 days have passed, the goods are permanently hot. Section 212A does not prohibit the shipment or sale of goods where the initial shipment does not occur until the goods have cooled. FLSA Section 203L defines oppressive child labor as a condition of employment under which A, any employee under the age of 16 is employed by an employer in any occupation, or B, where any employee between the ages of 16 and 18 is employed by an employer in any occupation, one of the 17 HOs declared to be hazardous by the Secretary of Labor. Here are two examples of where hot goods could apply. Section 212A would apply where 14 or 15-year-old minors are employed to load boxes on trucks at a bottling company and deliver it to households if the bottling company produces some of its goods for shipment in commerce. This employment constitutes oppressive child labor because such work is prohibited by sections 570.33K and N. The hot goods provisions of section 212A would also apply to the next example, where a 15-year-old minor works as a cashier in a small retail bakery that makes cakes and pies, some of which are shipped or delivered for shipment in commerce. Assume the minor does not handle checks or credit card transactions. Because the ADV of the enterprise is under $500,000, the minor would not be covered on an enterprise basis under Section 212C. Because the minor is not employed in commerce or in the production of goods for commerce, he or she is not covered on an individual basis. But since this minor's employment was in violation of the child labor standards, working until 10 p.m. in violation of the Child Labor Reg 3 hours standards, oppressive child labor would have occurred. The products produced by the baker during the period of the oppressive child labor and 30 days thereafter would be hot goods under Section 212A. I'll now turn it over to Serena, who will discuss the assessment protocols.
Thanks, Ernie. In terms of the process of a child labor investigation and the assessment protocols, the investigator first conducts the child labor investigation. When child labor violations are found, the investigator may put the employer on notice with the WH-103 and make a CMP recommendation in the narrative. The file is then submitted to the investigator's supervisor for their review. The investigator's supervisor, either the DD or the ADD, who is responsible for assessing the child labor CMP, reviews the child labor case to ensure the investigation findings are accurate and that each child labor violation is adequately substantiated. The DD or ADD assesses the child labor CMP. If an employer appeals the assessment of a child labor CMP and the case cannot be settled at the district office level, the file may be sent to the regional office for further review and possible settlement, often in consultation with the regional solicitor. Finally, the regional office and the regional solicitor may consult with the national office FLSA child labor team when reviewing and attempting to resolve a child labor CMP assessment. Cases involving injury or death, the regional office and national office will generally hold a telephone conference with the district office, the regional solicitor, and national solicitors to discuss the pending child labor CMP assessment. These conferences have been extremely important in shaping the assessment strategy and ensuring consistency and a successful outcome of the assessment process. Assessing officials require the approval of both the regional office and national office before assessing child labor CMPs in cases where the CMPs exceed $50,000 or involves any serious injury or death. In addition, national office and regional office approval is required for the CMP assessments involving non-exempt minors working in covered non-agricultural employment who are under 14 years of age. This violation is charged only once per minor and is in addition to any other violation that might also have occurred, such as any Reg 3 or HO violation. This CMP shall not be reduced by the small business reduction. For clarification, a non-exempt minor is one who is not subject to the child labor provisions of the FLSA due to other exemptions such as the parental exemption or the exemption for employment as actors or performers, for example. It has no bearing on whether the youth is subject to the minimum wage or overtime provisions of the FLSA. Please see FOH Chapter 33E for more information on child labor exemptions. The assessing official shall review every child labor CMP case to ensure the investigation findings are accurate, documented, and have been entered into Wizard. In addition, the file shall be reviewed to ensure that all the required statutory and regulatory factors have been given proper consideration with regards to the recommendations for child labor CMP assessment. After reviewing all the statutory and regulatory considerations, the assessing official has the authority to make a pre-assessment adjustment and reduce an initial penalty assessment amount by 25%. Any assessment involving serious injury or death, or if an initial child labor CMP is in excess of $50,000, the assessing official must obtain national office and regional office approval before a pre-assessment reduction may be made. The justification for the reduction must be based on the regulatory factors and be documented in the case file. The same applies to a post-assessment adjustment. However, the initial penalty assessment amounts may be reduced by 50% using the factors previously discussed and located in 29 CFR Part 579. The regional office approval is required for any reduction greater than 50%, including any reduction greater than 50% the assessing official intends to use to settle the case. As previously stated, no reductions are permitted for serious injury, death, CLEPP or non-CLEPP, or violations involving youth who are too young to legally work without prior regional office and national office approval. Now I'm going to turn it over to Derek, who will be discussing the roles and responsibilities and asking for questions. Derek?
Thank you, Serena. This slide provides an overview of the roles and responsibilities of the wage and hour investigator and the assessing official. This chart is only being provided as a job aid. As we all know, investigations can take many different routes to achieve compliance, which is our ultimate goal related to the safety, health, and well-being of our youth. However, I would like to emphasize that entering the correct and appropriate data in Wizard is imperative based on the investigative facts and findings to determine the proper CMP recommendation. In addition, the child labor CMP assessment is key based on all violations and mitigating factors. Please be mindful of the RO and NO approval requirements when encountering a serious injury or death, CMP amounts over $50,000, as well as systemic violations determined through the course of the investigative process. This concludes today's webinar about child labor coverage, CLEPP guidance, the IAA provisions, and the factors utilized in determining the CMP amounts. For additional information on the child labor ag and non-ag provisions, please review our resources listed on the slide, which includes the 2010 preamble, recently issued FAB and WAM, updated FOH internal and external chapters, fact sheets, and the revised child labor CMP tables for both the ag and non-ag provisions. We will now take the remainder of the scheduled time to respond to some of your questions. As a reminder, If you have questions, please type them in the box of the Q&A panel. Due to the volume of the inquiries and time constraints, we may not be able to answer all of your questions. Thank you for your patience and participation today. We will now start our Q&A segment momentarily.
Thank you.
All right. One of the first questions we have, will the CMP publication, Wage Hour 1415, be updated to include the new CMP data? At this particular moment, we do not have a set date for that publication update. However, if you would please use the CMP links that were provided on our website, as well as the two ag and non-ag child labor charts that were provided as well, that would keep and provide you with the most current updated information. Please keep in mind, as it relates to the factors, 579 and 580, those particular factors are still current and relevant, so that particular portion does not necessarily need to be updated. So we'll move on to the next question.
So we had a couple questions about the small business reduction. One is the small business reduction used on CLEPP due to the number of workers. The small business reduction is considered by Wage Hour when the employer employs fewer than 100 employees. We also had a question about, does it apply for CLEPP violations when computing CMPs? And you want to look at review section child labor CMP reductions based on mitigating factors and the size of business. And you can find that specifically on pages 15 and 16 in the FAB 2016-5.
Another question we have is there an adjustment to the CMPs if coverage is strictly on an individual basis? And the answer is the normal CMP procedures would apply whether coverage is on an enterprise or individual basis.
We also had a question about reviewing the de minimis factor considerations. And these are specifically listed on page 10 of, again, FAB 2016-5. Wage Hour generally will not assess a child labor CMP for violations that determines to be de minimis. And there's two things that we look at here. It includes de minimis violations includes those which are record-keeping violations that involve the employment of no more than one minor, and no other child labor violations are documented in the investigation. And number two, violations of child labor Reg 3 hours standards. And again, those are on page 10 of the FAB for additional information.
We have another question. Does all the criteria need to be met for it to be under CLEPP? Yes, they all must need to be met. The three criteria here would be permanent loss of any senses, sight, hearing, taste, or smell, permanent paralysis, or substantial impairment.
Another question has to do, is a global question, and wanted to know if the training is going to be saved and posted on the internet. And yes, the training is going to be uploaded to our intranet. And again, this is an internal presentation and is only for wage hour staff. So this training would not be shared with the public.
And in addition, there's also going to be a part 2 to this. We will also have a learning link made available relatively soon, within the next 3 to 4 weeks, to also be as another level of assistance to the guidance document that we have. And so that would be utilized for our internal staff as well. And all of these will be housed so you can refer to them throughout the parts of the presentation.
We had a question about HO16. Does it include prohibiting installing insulation on the ceiling inside a building? HO16 only applies to roofing operations. For additional information, you can look at FOH 33H16D1 or in the regs at 29 CFR 570.67B.
Another question requests clarification. We were talking about impairment ratings and who should be contacted, and it was basically the investigator should also ask whether the state's workers' compensation office has issued an impairment rating regarding the injury.
So we have one other question. Will there be additional training for investigators? For example, what questions to ask? As it relates to the presentation and any additional trainings, you can always speak directly with your regional enforcement coordinators. If there are certain questions or certain other job aids that might be helpful, and we can work with your regional enforcement coordinators in that space. We also will be providing additional an extensive, comprehensive child labor presentation that will be updated and that will be shared with our internal staff as well. But as it relates to any other particular questions to ask, we can make sure once we go through our particular notes what additional job aids would be helpful for you. Well, coordinating that with your regional enforcement coordinators is a very helpful process to start as well. Okay, one other component, you guys, we ask a decision tree for CLEPP. And obviously, definitely, we're working on that. We wanted to make sure that the child labor presentation was provided, and it's definitely about 90% completed. We wanted to make sure that all the terminologies are correct and that we factor it through and run it through your regional enforcement coordinators. So yes, that will be coming very, very, very soon as well. I keep saying very soon, but if I say it out loud, know that it's going to come. I'm a man of my word, so it will happen. We have one more question. We appreciate your patience with working with us and the technological issues that we had. Our apologies, but do know that a recording of this webinar will be online, and it should be a very clear recording if you want to utilize it again. Ernie is going to answer our last question, and we would definitely appreciate your patience.
So the question we had was the difference between CLEPP and non-CLEPP. Again, we talked throughout the presentation about CLEPP. Looks at direct causation, it looks at the permanent loss or injury, and it also looks at the two factors under the causation standard, the but-for causation and the foreseeability. Non-CLEPP is a lower standard to meet. Again, the violation only has to contribute to the child labor injury or death. It doesn't have to be a direct causation there. So, and again, obviously the penalties are going to be higher for CLEPP versus non-CLEPP.
I would say, closing out, one last factor. Many times we have sub-regulatory guidance, such as our AIs and our FABs. I do believe that this FAB is written in a manner that allows you to look at the different categories, Category 1 CLEPP and Category 2 non-CLEPP. And within those FABs, there are specific examples, and the same examples are used for CLEPP when it meets those two standards and when it doesn't meet those standards for as non-CLEPP. So I would utilize those FABs and look at the FABs to make sure that I'm following those presentations, the actual requirements. In the FAB is great. Also, our FOH actually has been updated to assist with FAB, with CLEPP and non-CLEPP as well. So please utilize those as well.
And one other note, if you want to look specifically back to the slides, CLEPP dealt with slides 17 to 21, and non-CLEPP were slides 22 to 30.
And again, the presentation will be posted on the internet.
Thank you so much for your patience.
You.
Enjoy your day. Thank you. This is ending our presentation.
That does conclude today's conference call. We thank you all for participating. You may now disconnect and have a great rest of your day.